Britain does not ban groups just because ministers dislike them. At least, that is not how the law is supposed to work. A ban under terrorism law is not just a headline, a press release, or a political signal. It is a legal power with a threshold, a government process, parliamentary approval, criminal offences, and a route to challenge. But once that power is used, the consequences reach beyond the organisation itself. Membership, expressions of support, supportive meetings, displayed symbols and online images can all become part of the criminal law. So the real question is not only, should Britain ban a group? It is, what power does the state gain once it does? In Britain, when politicians or journalists say a group has been banned, they usually mean it has been proscribed under the Terrorism Act 2000. That means the organisation is added to Schedule 2 of the Act, the UK's list of proscribed organisations. This is not a rare or unused power. More than 80 organisations are currently proscribed under the Terrorism Act 2000, alongside 14 Northern Ireland organisations under older legislation. So how does a group end up on that list? The legal starting point is Section 3 of the Terrorism Act. It sets out a two-part test. First, the Home Secretary must believe the organisation is concerned in terrorism. Second, they must believe proscription is proportionate. That phrase, concerned in terrorism, is broader than many people assume. Under the Act, it covers committing or participating in acts of terrorism, preparing for terrorism, promoting or encouraging it, or otherwise being concerned in terrorism. And the definition of terrorism itself is wider than just violence against people. It can include serious damage to property, serious risks to public safety, or serious disruption to electronic systems, if the aim is to influence government or intimidate the public in service of a political, religious, racial, or ideological cause. That is why the word terrorism in law can sometimes reach further than the word does in ordinary conversation. But even if that threshold is met, the Home Secretary still has to consider proportionality. That means looking at the scale of the group's activity, the threat it poses to the UK, the threat to British nationals overseas, the extent of its presence in the UK, and the need to support international partners. The Home Office works with operational partners and other departments through the Proscription Review Group. So the final sign-off is political, but the process is meant to be structured, evidence-led, and security-focused. Once the decision is made, the group is not banned by a simple announcement. The government must lay an order before Parliament. For a full new proscription, both the Commons and the Lords must approve the order. Parliament cannot rewrite it. It is a yes or no vote. There is one important exception. If the government is adding an alias or alternative name for a group already on the list, that is handled differently from a full new proscription. This is where the process becomes real. Once a group is proscribed, a range of activities become criminal offences. It becomes illegal to belong to the group or to claim to belong to it. Under Section 12, it is also an offence to invite support for the group. And since changes made through the Counter-Terrorism and Border Security Act 2019, the law can also catch clear expressions of support where someone is reckless as to whether others will be encouraged to support the organisation. That is where the speech versus security argument becomes real. The law also covers meetings. Arranging, managing, or speaking at a meeting that supports the group, furthers its activities, or is addressed by someone who belongs to it can become an offence. Then there is public display. Wearing clothing, carrying items, or publishing images such as flags or logos can also be criminal if it arouses reasonable suspicion that the person is a member or supporter of the organisation. The penalties are serious, but they are not all the same. Membership under Section 11 and support offences under Section 12 can carry up to 14 years in custody. Public display offences under Section 13 carry lower maximum penalties, but they are still criminal offences. And a terrorism conviction can have consequences far beyond the sentence itself. This is why proscription matters. It does not just signal disapproval. It changes the criminal law around membership, support, meetings, symbols, images, assets, online material, immigration powers, and public expressions of support for a group. So why do governments use it? Because it is designed to disrupt. Supporters argue that if a group is genuinely concerned in terrorism, the state should not have to wait for more harm before acting. The power makes it harder to recruit, organise, raise funds, or operate openly. In that view, proscription is prevention, not just punishment. Critics argue the opposite risk. Because the legal definition of terrorism is broad, proscription can reach speech, protest, and political debate, especially when a group's activity sits near the boundary between direct action, criminal damage, and terrorism law. The question is not whether the state should protect the public. Of course it should. The question is how far the state should be allowed to go when protection starts limiting expression, association, and political activity. Recent cases involving protest movements, direct action, and terrorism law have intensified that debate. And a ban is not necessarily permanent. Section 4 allows the organisation or anyone affected to apply for deprescription. The Home Secretary must decide within 90 days. If refused, it can go to the Proscribed Organisations Appeals Commission and potentially to the Court of Appeal. In contested cases, challenges may also raise Articles 10 and 11 of the European Convention on Human Rights, freedom of expression, assembly and association, especially where proscription affects speech, protest or public support. Even if a ban is lifted, Parliament must still approve the removal. So proscription is a legal process on the way in and a legal process on the way out. That is the system. The Home Secretary initiates it, Parliament approves it, the police and courts enforce it. The banned group or affected people can challenge it. And the public lives with the consequences. Before asking whether any specific group should or should not be banned, the tool itself has to be understood. Because proscription is not only about what a group has done, it is about what the state is allowed to do in response. And once that power is used, the argument is no longer just about one organisation. It is about where Britain draws the line between security, speech, protest, and public power. Next time, Britain First, Explained.